I wanted to
Yeah.
go, but um, I'm just in the cusp of moving, and I booked a week off holiday at the work, and it's going to be when I move. It's like it's timed really well, and I'm like, oh God.
Yeah,
But yeah, it's really good. So I'm trying to pack in.
yeah, cool. Hey, right, everyone, just bear with me whilst I do the usual bits here. So it's just me and Karis this week. Will is otherwise engaged. I think Shannon's off this week. Done that, done that. So yeah, usual. I don't know if we're going to get many people tonight because it's quite a last minute thing that we're doing on Wednesday this week rather than Thursday. But we'll see what happens. If you're here, say hello. Nice to hear who's here. So yeah, we've got five questions that have come in through the week, four of which were anonymized. So we'll do them pretty shortly, and then we'll get on to the anonymized ones in the live chat, and then we'll finish off with the ones that aren't anonymized from the week, which is just one, I think, if I've been paying attention. Um, Usual stuff. Hey, watch, I don't know. It's not legal advice. We're doing our best here to be helpful. But obviously it's not always possible to follow this stuff anyway. So I will be sharing the link fairly shortly that kind of enables you to approach Virgo solicitors if we basically think that's what's advisable. Obviously, hopefully sometimes you'll be able to sort things out yourself, but certainly when it comes to things like priority need and just when council has been very difficult, it's probably better just to get a solicitor if you can. So, Karis, what's your capacity like at the moment? Is it nightmarish, or is it? Have you can? That's a face there. I mean, okay. So, I mean, as all these things are, guys, it's going to be dependent on capacity. So, you might approach Virgos and they just haven't got time at that point. So, yeah, and yeah, as always, just keep questions in the comments anonymized. So just ask them as what if questions rather than stuff that's disclosing information about you and your family. So you'll get the same answer if you make it a what if question. So let me get the blank sheet up. And the first question we've got, there were a couple which they're interesting ones, and I'm not quite sure. Yeah, I'm not quite sure what the answer is actually, but we'll see how we do. This one's first one's pretty standard, I think. So my friend put in a homeless application to a council they lived in for the last 8 years. But recently moved away with her boyfriend. She has a baby and was experiencing domestic abuse. The council offered no help, said she was in no danger and wasn't homeless, as still has a roof over her head. They also said to approach her local council. If she takes emergency accommodation from a local council, will she be able to move back to the area she is from if she's eligible for permanent housing? So, um, effective. I mean, we'll go through some basics here because although this is like the law's not complicated here at all, it's just the councils repeatedly don't follow it, which is astonishing and depressing at the same time. But basically, you might have a roof over your head. That doesn't mean you're not homeless because of domestic abuse. The legal test of homelessness for domestic abuse is where remaining in your home is probably going to result in further domestic abuse. And we know that domestic abuse it can be very subtle. It's generally an escalating pattern of behavior. So if you've experienced one instance of domestic abuse, it's not, it's probably almost kind of probable that it would continue just on that fact alone. So we've got two councils here, and I'm going to refer to the council that this person lived in for 8 years as Council A. They've then moved to Council B, where they have then experienced domestic abuse. And it sounds as though this person wants to return back to Council A, if I'm reading that correctly. And in one sense, in that situation where you know where you want to be, you're better off just directly approaching that council. You can approach any council you want if you're homeless at all, particularly when you're experiencing domestic abuse. Um, but basically, in this situation, if this person wants to live in Council A's area, then it's better to approach Council A. It still doesn't actually guarantee getting housed in Council A's area because they can still house you somewhere else, but it maximises the chance of that happening. And in effect, the local government and social care ombudsman makes it clear that the default position of council should be to believe people who disclose they've been abused. So you shouldn't need any additional evidence, but in the real world, it's going to make things far less stressful. So I would say one thing this person could do is approach local or national domestic abuse support services. I'm not an expert on the national ones. My experience is generally there'll be a local one in your district, and my experience of local ones is they're really good. And there will definitely be a local IDVA service. So you can self-refer to the IDVA service. If you Google a dash form, domestic abuse, stalking, harassment form, So you'll get the form. I think it's on Safe Lives website. I can't remember, but you'll find it. And there's basically like 27 questions or something. Do the questions, depending what your score is. Essentially, anything over 10 really is probably going to get, it's probably result in getting an IDVA. I'm not sure if they like you doing it yourself. They tend to like referrals coming in from support agencies. There's nothing stopping you doing it yourself. And on there'll be some details somewhere that you can Google with your local council, which is like the address to send it to. So if you Google your local council's name plus the term MARAC, MARAC, multi agency risk assessment conference, they'll have an email address there. If you send a dash form just to explain the circumstances, they should assess it and hopefully you'll get an IDVA. Now, as I said, you shouldn't have to do this, but it might make it easier to do. And you could do that to Council B's area if you wanted to. In fact, given that you're living there at the moment, I'd say go to Council B's IDVA service, because that doesn't tie you into approaching Council B for housing support. You can still approach Council A or any other council you want to. So, but what is not going to happen is if you approach Council B's area and kind of fight through the initial gatekeeping, and they turn out that they owe you the main duty, they're not going to transfer you out to Council A's area. It's just not going to happen in the real world. So you're better off approaching the area that you actually want to live in. So yeah, obviously, I guess it's probably worth saying as well. Like you can go to the police. I appreciate there are reasons why not everyone wants to go to the police, but you can go to the police, and the police should be good at picking up on all forms of domestic abuse, not just physical violence. But I mean, I was at a conference a couple of weeks ago, and it's interesting. They said it a few times that coercion and control is actually the most dangerous type of abuse. That's the one that's like the most likely to result in homicide. So yeah, so it's that, and that can obviously be very subtle. So just to make the obvious point, just because you might not have been hit yet, but that doesn't mean you're not subject to domestic abuse or at risk of it. So yeah, I think that is my answer. Karis, have I missed anything? Do you want to add anything to that at all? I'll take your silence. Is it all right?
Yeah, no, it's good.
Cool. Okay. So next question. This is an interesting one. I think I know the answer to this. We'll figure it out together here. So basically, what happens if someone has been given interim accommodation after Section 21 expired, which is the way it should be done, by the way, generally speaking. But the council are now saying to the person they're not in need of emergency accommodation because they still have the keys to old property because of the delay in moving stuff out. Also, the council said the notice to the landlord wasn't required, whilst letting agency says they need to give a month as a rolling tenancy. So I'm pretty sure in that last part of the question, the council's correct there. The letting agency, unsurprisingly, doesn't know what they're talking about. So because the landlord's already given notice, the Section 21's already expired. You don't need to then, the tenant doesn't need to give notice now that the landlord's given notice. So that deals with that bit. In terms of this first bit, so I should probably open up the Homelessness Code of Guidance here, because we need to, this is a good opportunity just to kind of see how a few bits of the law interact with each other. And what's my computer not working properly? Hold on. Try and find my code of guidance here. Got multiple screens up, which is why this has been difficult. Still not working. Awesome. Let me just stop sharing for a minute, see if it does gets that better. So yeah, it's still not working. Or just get rid of everything. Sorry about this, guys. If I was thinking ahead, I would have done this. Oh, I know what the problem is as well, actually. But anyway, yeah, here's the Homelessness Code of Guidance. So I mean, I'm assuming that this person, there is a reason why they're in priority need. They might have a child or something like that. It's probably the most obvious one. So, oh my gosh, I've now vanished, it seems. Here we go. Been a long old day. So yeah, here's the Homelessness Code of Guidance. You can Google this. Freely available PDF. You get the most recent version. It's the rule book that councils have to follow, and it's written in layman's terms, so it's awesome. So basically, if we just go to 6.35, we can introduce these things. So 6.3, let's go to the next one. Here we go. So this is where this council's actually got this right, which is, as I say, quite unusual, it seems, at the moment. So the Secretary of State considers that where an applicant is an assured short hold tenancy who's received a valid notice in accordance with Section 21 of the Housing Act 1998 and the housing authority satisfied the landlord intends to seek possession, and there would be no defence to an application for a possession order, then it is unlikely to be reasonable for the applicant to continue to occupy beyond the expiry of the valid Section 21 notice. So, and there's some small print there which you can kind of look at in your own time, just kind of zoom in on or whatever, just pause it. But so when your so in most cases, when your Section 21 expires, as in the day after your Section 21 is kind of expiring, that is when you're probably homeless, because the term basically reasonable to continue to occupy is basically a code for homeless. So if it's unlikely to be reasonable to continue to occupy, then you are likely to be homeless at that point. And if we go to 15.4, this is when the interim duty to accommodate kicks in. So section 108, subsection 1, requires blah 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 housing authorities to secure accommodations available if they have reason to believe that the applicant may be homeless, effectively may be eligible, and may have a priority need. That's how you read it. So the fact there's may at the beginning means it applies to all three. And so if someone's Section 21 is expired, it's likely they're going to be homeless. So there's going to be reasons to believe they might be homeless unless one of the kind of other criteria don't apply or whatever. And if you're, let's say, you're a UK national in receipt of benefits, just to make it really, really crystal clear, and you have a dependent child, then the interim accommodation duty kicks in. Now, you don't have to give up the keys on your property. You might still have access to that property at that point in time. And so they would be, yeah, so the duty would kick in. Now, I guess the council might be trying to argue that because this person hasn't given the keys up yet, that they are essentially trying to secure the accommodations available by saying that they can go back to where they were living before. This is where I'm a little bit in kind of uncharted territory. So it's a shame Will's not here because he's been doing this 40 years. He probably knows better than me and Karis. But I would say that might be what they're trying to say here. That then brings in this other element of the question, which is about kind of the fact that they haven't been able to move their belongings out. And it's important to say, in fact, if I stay in the Code of Guidance actually for a moment, because in Chapter 20 of the Code of Guidance is all about the protection of property. And effectively, this person there may be a duty for the council to actually protect their property by basically storing it or transporting their belongings themselves. So essentially, where there is these three criteria applying, so there's danger of loss or damage to the applicant's property because the applicant is unable to protect it and no other suitable arrangements have been made or are being made, then the housing authority must take reasonable steps to prevent loss or will prevent mitigate damage to any personal property of the applicant. So this, again, this is a bit of grey area. This might kick in at this point. So because if the reason for you not giving your keys back is the fact that you haven't been able to store it or transport it yet, then potentially that duty would apply. So let's see where that leaves us. As I say, I've had a really long day today, so my brain is a little bit fried. So yeah, I think the council's wrong, but I do probably see why they're saying what they're saying. And I think the answer is to probably, I mean, with the council's knowledge and with their advice, is to basically give the keys back, for want of a better word. And if that means that this, kind of the old property, the delay in moving stuff out is the problem, then potentially talk to the council about whether they can actually help out with it, whether they got a duty to help out with that. That might be the end here. Because what I mean, a lot of councils, as I say, like it's surprising that this council's even kind of enacted Section 188 at this stage, because most councils tell people to wait until the bailiffs come, which is definitely unlawful. But if the council has provided interim accommodation and this person or this family has still got the keys and they're still accessing the property to kind of come and go, or whatever, I can kind of see what the council's saying. But yeah, so yeah, it's a bit of a messy one. I might have a think about this in the week or something and come back with a more comprehensive answer next week. Karis, have you got anything to kind of to add on this one? As I say, I've never come across this. Generally speaking, in my experience, when the council finally accepts that Section 108 has been triggered, they don't tend to go back on it. They don't even kind of bother going back on it. In fact, they don't even have the administration facilities to actually go back on it anyway. So yeah, have you got any thoughts on that?
No, that is true. But I would say this, if they've not made a decision, then you can challenge if they have made a decision and this is a final decision, you get your section 202. So you can challenge it for a review that way. But just because you've got the keys, I would say it's no longer you have no longer the right to remain in the property just because you have the keys, and even though you haven't fully moved out yet, I wouldn't say that's a reason that you can still stay there and invalidate the need for emergency accommodation. And so you can complain about this. This does happen. They go, oh, wait, we were too soon. But yeah, they're doing what they should be doing, which is not delaying and so you can move out. But it's wrong in terms of what they're saying. Just because you've got the keys doesn't mean you're not in need of that emergency accommodation because you don't have the right to remain there. Um, and you can't be reasonably expected to remain there, and you have no legal right to occupy the accommodation anymore because of the Section 21. So you can put a complaint in at that. And if they've got a decision, given you a decision, they're actually saying no, you can challenge it through Section 202.
Yeah, that's really good. Yeah, there's a really good point about, yeah, I think for councils to try and take this course of action, they're going to have to issue a not homeless decision. As I say, it's really interesting. It's just a grey area. And I guess the other thing as well, and Karis, you probably know the answer to this, but landlords can't chuck your stuff out immediately once you have given the keys back. I think they need to retain it for like, I'm not sure if it's set out in law. I think Will said it's like 28 days before, but I've seen elsewhere it's less than that, like sort of 14 days.
So
So, but there's that might come into play a little bit as well here.
yeah. And
Um,
if there's a delay in moving out, they would have said, oh, there would have been a reason for the delay, and it's a valid reason. We're still getting some stuff out, but they have a right to protect your right on that point to protect property.
yeah,
So
cool.
landlords
Okay.
don't necessarily, but some landlords will just put them out with the suitcase if that's rogue landlords.
Yeah, yeah. Okay, so next question. Question three. What if temporary accommodation is a hotel? Can you ask for housing benefit directly uh, directly paid for the hotel by yourself? Hold on a sec. Can you ask for the housing benefit directly and pay for hotel by yourself instead of council making booking for you and potentially threatening or even moving you to another hotel? So you um so my understanding is, and again, this is I'm in uncharted territory with this one as well. You used to be able to get housing benefit for hotels, no problem. However, these days housing benefit only applies to like temporary accommodation, supported accommodation and stuff, although there are some areas it gets complicated because some other areas still do have housing benefit. So I think in this situation, first of all, I don't know how you're going to afford it because yeah, I'm not quite sure how many hotels are really. It's not. I don't know. I don't know how that's actually going to work out in terms of the mass of it. Because certainly the situations I've seen this before, people were not getting like enough money to actually cover hotel costs. They were getting like a set amount a night, like £15 a night or something. And obviously hotels are going to be a lot more than that. So generally, yeah, I don't know how the funding arrangements work for TA exactly with housing benefit and kind of councils TA budgets and stuff. Um,
It's a
I
benefit.
yeah, go sorry, going Harris.
Yeah, and I don't think so because also they charge service charges and stuff. So I would say no, they wouldn't.
Yeah.
And
So
potential moving, the council have an agreement with the hotels. They'll move you sometimes regularly. So people will be moved a couple of days in one hotel, a couple of days in another hotel.
yeah, I mean,
There's a,
let's say you had like £5,000 savings or something, and you were financially able to do that. Then even then, you just want to be very careful what you're doing here because I mean, I think this came up in a video I did this week where basically it comes from a case called Edwards v Birmingham, and essentially the interim duty might kick in. You are at liberty to say to the council, look, actually, I could stay with family for the time being, or I can make my own arrangements for the time being. And the council should basically say, yeah, that's fine. But if things change and you need us, then come back and we'll provide the interim accommodation. I'm assuming we're talking about interim here rather than TA, temporary accommodation after the decision being made. But anyway, so yeah, I mean, I think the answer here is to be sure is to go back to the council and say, look, I have a bit of financial resources, or I don't have any financial resources. What are my options in terms of choosing a hotel? I think you're probably going to get a negative response, as in they'll just say that's not workable, or like, yeah, that's great. If you've got £5,000 up your sleeve, then great. But yeah, that would be kind of the approach there. So Yeah, again, I've not had experience of it. Not been very helpful yet today. It doesn't feel like it, but yeah, that's probably what you need to do. I think whatever you need to do it in agreement with the council anyway, because if that's what you're going to do, you need to get them to say in writing, yes, we understand you're doing what you're doing here, and we're going to continue like knowing that the duty is there. Because what they could do if you don't tell the council what you're doing, and you just basically leave one hotel, move into another, then they could essentially say, okay, well, you've just refused an offer of accommodation, therefore we're going to end the interim duty. So, or in fact, if it was temporary accommodation, if it was the accommodation after the decision been made, then they could basically end that duty as well. So you need to basically, yeah, hash it out with the housing officer basically and get anything in writing. Don't just do it on a what's said in a phone call. You need to actually get what they said in writing in an email so you can prove should you need to use it down the line. So yeah, yeah, again, yeah, that might be the best we can do. And then the final question that was anonymized that came through the week is this one here. It's a bit longer. So what if back in 2021 someone was rejected from the housing register because they were not legally overcrowded because their two children were under 10 and in a one-bedroom flat? The flat became unaffordable and unsafe with dangerous windows and fourth floor. The council didn't help as not statutory overcrowded. The housing association promised to rehouse them in London with London partners, but instead put them on a register outside London. They accepted the house in desperation for their kids' safety. Now they live miles from their family in another city and their asthma has worsened, including a life-threatening attack. They've asked both the Housing Association and Council for help to rehouse them near family support, but each refers them to the other and won't help. Is their request for Housing Association to honour their original promise and the Housing Association and Council to work together reasonable? So, yeah, I think it's reasonable. I mean, so let's just try to unpick this. So, this family has moved to another city. There's not any. I might be missing something here. There's this kind of issue of like serious asthma. I'm not seeing how that's specifically connected to this new property that they're living in. I don't know if I'm misreading that or maybe just kind of presuming something there. So, um, so I guess the question is if they've been moved to into social housing in another city, the question is, what is it about that new accommodation is that makes it unsuitable for some reason? And if it is the support network, I mean, maybe what they're saying is, the kid with the asthma, actually, the effects of the asthma means they kind of need like more support or something like that, and they don't have that support network locally. Maybe that's what they're saying. And so, can they move back to how do they move back to their original place? Now, I don't think you can do this through the council's kind of homeless, certainly not kind of a homelessness issue. I don't think here, unless let's say for example the asthma was caused by really bad damp and mold, something like that, that might kick in. But I'm not seeing that in this information. So I think then the question is, okay, it's going back to what the housing association originally said. So if they promised to rehouse them with London partners, I guess you'd want to get that when they said that to you in writing and actually unpick what they exactly they said, because they'd probably been very careful what they promised and what they didn't promise. And just the fact to say, "I'll put a house with London partners." What were those London partners? Are they listed somewhere? Does that actually mean that you're actually going to be guaranteed to live in London? Those are kind of things that I think would kick in here. So um, yeah, I don't know. You can always apply for social housing in the area with your support network, but that's not going to work anytime soon, basically. And you might not get, you might get assessed and get rejected because you haven't got enough needs or whatever. So I think, yeah, that's again, there's a limit to what I can say there because I don't see what I'm not quite sure exactly what's going on here in their new property. Whether it's solely the fact the kids have this, one of these kids have this real serious health issue and they need their wider family around them to help them out, or whether there's something else kind of that I'm missing. So that's also quite a vague answer. Karis, you got any ideas on this one?
Well, you can ask for a review of the situation, and it's unreasonable to continue to occupy if it's a danger to your health with the damp and mold, if it's the kids. So it would be unreasonable to continue to occupy um the house you're in now and apply, yeah, back, like you said,
Yeah, I'm
back
just
into it.
I'm sort of speculating whether that's actually the case. I mean, I think if it is an issue that the housing association promised something that they're not fulfilling, then formal complaint to the chief exec, get ChatGPT to help you out if you want a bit of help writing it out. Keep the complaint nice and short and put numbered points in it so it just becomes easy to follow and stuff. But I don't think I don't think the council will have a hand in this. Basically, I think it's going to be down to the housing association. It'll be a case of, as I say, digging out the policy or digging out the promise that they said to this family, and complaining that it's not been, if the small print says that it's not been followed, then complain based on that. But I think other than that, I'm not seeing any kind of clear ways of doing it.
And get documentation of the deterioration in health.
Yeah, yeah, particularly if it's kind of tied into something about the property, or like if it's kind of, if it is something about the kind of the need to be close to relatives and stuff like that, that's not going to harm you. I don't know it's really going to speed any process up either, to be honest. But it's stuff you can put in the complaint anyway. Cool. So on to the live chat. If I can actually get this to copy and paste. Oh, let's get rid of that. So in a scenario where a single person is in temporary accommodation for 4 months, is there a claim for compensation with the LGO, or is it just for families? So I'm guessing here when we talk about TA, we're talking about sort of hotel accommodation rather than just TA, because obviously people can be a T and TA for years. What is considered too long in TA? So, okay, so if I'm reading that right, so let's talk about the families and hotels. So the code of guidance says that council should not house families with either children or pregnant women in hotel accommodation at all. And then it says if you absolutely have to, you can do it for no more than 6 weeks. And if they do it for more than 6 weeks, you get between £100 and £200 per week if you bother complaining to the council, then to the LGSCO. So there's a limit on the amount of time that that a family can be put in hotel B&B type accommodation, shared facilities, that sort of thing. But for a single person, as far as I know, there is no such limit. I mean, we can have a little dig around in the code of guidance, although I don't think I'm going to be able to find it. It'll be in chapter 17, basically. If I search for the term B&B, see what we get. Awesome, it's not coming up at all. It's in there somewhere. Hold on. Search for 6 weeks. So, and let me just share this screen as well so you can see what I'm looking at. So yeah, so it's rather wordy here, but it's yeah. So if we just go back to, so first of all, it kind of defines what a B&B is. There's a really weird exemption which I'm not going to go into because it overcomplicates it. Um, Probably missed a little bit of this out here. So yeah, here's the kind of, okay. So housing authority should therefore use B&B accommodation to discharge a duty to secure accommodation for applicants with family commitments only as a last resort, and then only for a maximum of 6 weeks. So applicants with family commitments means an applicant who is pregnant, with whom a pregnant woman resides, with whom dependent children reside. Okay, so that's that bit there. So if there is anything in there about single people, it'll be in here, but I don't think there is. There's stuff about standards of B&B type accommodation. And I have seen cases where people have got compensation because, let's say, there was no cooking facilities, and as a result, the person had no option but to continually buy, kind of effectively, ready-made food in supermarkets, stuff like that, which is obviously going to be more expensive. I have seen cases where the LGOs recommended compensation for that sort of thing, but not a lot. It essentially just covers the amount of money that the person spent out. But other than that, I don't think there is anything in there which would kind of restrict it. So I think in that sense, I don't know there's anything stopping councils housing people, single people in hotel accommodation for potentially years. I've never seen anything that says that. But if it does say something like that, it'll be in this area here. You can kind of see the subheadings here that are also relevant for a lot of people. So location of accommodation, that sort of thing is going to be potentially helpful as well. But I think the answer to that question in short is I don't think there's a limit on single people being in B&Bs. There is a limit for 16, 17-year-olds, but I appreciate that's not what's been asked here. So, hey, you right, Cheeseface? Thanks very much. So again, just to say, guys, I'm just going to remove questions that are not anonymized. Yeah, thanks, Shadownet, for that. So question here. Hi, guys. The code of guidance needs to change for clarity. Whom could one contact to ask for changes to be made for the code of guidance? So many people fall short because of misunderstanding. So I mean, yeah, I mean, I'm all for like pushing for changes. The code of guidance basically gets changed significantly very infrequently. So this code of guidance has basically been in force in its current form really since 2018 when the Homelessness Reduction Act kicked in. And before that, I think it had been in a similar form since 2006. So, sort of like once a decade if you're lucky. However, there are very small amendments that get made. In fact, I'll give you an example of that actually, just to kind of familiarize yourself with the code of guidance. So, because if you actually go to the very beginning of the code of guidance, it gives you like a list of like changes over time. So when it says 22nd of February, it means they didn't even put a year in it, but you can see like over the course of the years, it does get tweaked very subtly. So, but it's not, we're not talking a lot here. So the last change was the 7th of June. In fact, if I go online, it might be a more recent update than that. But we're talking here, they kind of just play around with words. There's not really anything significant, and certainly the areas of the code of guidance which are the most ambiguous. Things like, I mean, although it does kind of say it, things like being asked to stay until the bailiffs come is said in a way which could be clearer. There's quite a few areas which obviously could and should be a lot clearer. But I think to kind of get that sort of thing changed, you're essentially writing to the Secretary of State, and I don't know what your chances are of them even kind of even knowing what the hell you're talking about. So um, uh, yeah, in at some point in the future, many years in the future, they're likely to rechange it again. There may be opportunity at that time to kind of some sort of consultation, but I think the really the kind of the I think if you're finding things that, finding areas which are not very clear, it might be worth investing in a textbook if you can get one. The recent textbooks tend to be very expensive, but you can generally get an older version, which might be actually still quite useful for even like, you get some old versions for like a couple of quid. And on some things, because they haven't changed over time, actually, they can still be quite useful. But yeah, I don't know. Yeah, so I don't want to kind of naysay anyone and kind of be pessimistic, but I don't think there's really any chance of anyone kind of getting the government to rewrite the code of guidance. Often the cause of that ambiguity is actually deliberate. So I would argue that the guidance around affordability was specific because there was a really good case in 2018 called Samuels v Birmingham, which was great, really clear, and then they brought in a new version of the code of guidance immediately after that, and it basically just introduced this ambiguity once again. And I think that was deliberate because basically councils or the government didn't like the Samuel's judgment. It was basically too good for homeless people. That would be my speculation on that. Um, so yeah, sorry to not be very optimistic on that one. Um, Next question. Where can a disabled wheelchair user friend get independent advice? I've tried a few times to ask. Over 2 years budget, hotel, no cooking or fridge or freezer, laundry. Indigenous in England, that doesn't make any difference. So, many people fall short because of misunderstandings. Yeah, so yeah, I think it depends on the nature of the question. I think is probably worth saying. So in terms of getting independent advice, in my experience, I have to say most organisations out there are pretty rubbish. I had a phone call from someone today from a local support service who are literally paid to support people, and they were asking me and expecting me to kind of, kind of go out my way to do their job for them because they didn't have a clue what they're talking about, and they'd worked for that organisation for many years. So I was like quite surprised, really. So there's a lot of charities which are pretty ropey. CABs can be good. It just depends on the kind of the expertise of the team because often they're run by volunteers. If you can get through to shelter again, they just kind of depends on which work you're going to get. So I think if you've got like a particular legal issue, as in the council's given you a bad decision or something like that, or there's flat out gatekeeping, then getting a solicitor is your best bet. And that's why we're talking about Virgo solicitors because we know that Karis and their team can kind of take cases on from all around the country when they've got capacity to. So yeah, and I think this kind of there's an element here which kind of it relates to a question from a couple of questions ago in terms of where you've got someone who's got no cooking and fridge freezer. So I might just have a dig around for an LGSCO case where that came up, and I might do a video about that at some point in the next few weeks or something if I can find one, because obviously I've talked quite a lot about the kind of 6 week limit for families, but I've not really talked about it at all for single people and actually the impact on people having to live in that situation. for for years is clearly it's not going to be suitable. I mean, that's kind of where the argument lands, is that your argument is the accommodation the council's given you isn't suitable for that length of time. It might have been suitable for a weekend or for a few weeks or something, but it's not going to be this, suitable for 2 years. So yeah, Karis, feel free to chip in as and when. Yeah, not this question there. So this is actually regarding question 2, which I think was remind me what that was. Oh, so yeah, that was kind of this idea of like councils advising people, unlawful advice. Councils break the law all the time. Basically, that's the answer, and they do so because not enough people push back. So if you don't vote, if you don't engage with your local councillors, if you don't kind of do this sort of stuff, then that's the kind of reason why nothing changes. We found in Bedford that a small number of people can get some really fantastic changes just by expecting the council to follow the law. So complaining when they break the law, exposing them publicly when they break the law, that sort of stuff. That's really effective. So yeah, so they're allowed to do it because yes. I mean, there's a really interesting kind of tangent I could go on here about how the law itself is a myth, in the sense that it's not a physical thing. It's not like the law of gravity. It doesn't exist if people don't believe in it. We have to believe in it for it to actually work. But the law is very powerful if you do believe in it. Basically, if you take councils to task when they're breaking the law, it's actually quite straightforward, relatively straightforward to get compensation in a lot of cases. The 6 week limit for families is a really good example because it is so easy to get compensation. But yeah, so and that same thing with being advised to stay until the bailiff comes. There's kind of the LGSCO has kind of put out multiple decisions where they've basically investigated those kind of situations and provided actually quite a lot of compensation. So yeah, but that's kind of partly why we do what we do, is not just to kind of help out individual people. It's to kind of get more and more people, as many people as possible, actually, kind of being outraged, because that's what it's going to take to actually get into to change overall. Okay, so think
And also the council aren't trained and have regular training. So they're kind of just left to their own decisions.
yeah. I mean, yeah, they don't know what they're doing. They don't think to ask. Um, they kind of shrug and say, "Well, that's just the way it is." And as long as people don't challenge them, that is just the way it is, really, I guess. There's just a multiple part of a question here. Nope, I don't want to do that. Hold on. So just to say, guys, you're better off putting the questions this long into any video in the channel, because you can just ask this as one question. The character limit's massive on the channel, rather than trying to do it over the course of 8 different um, bits. I mean, it's okay, but yeah, it'd just be easy for you guys to actually just put it on the audio. So let's see if we can kind of put this all together. So family was served a valid Section 21 notice. After it expired, the council accepted relief duty because they said they were severely overcrowded in the expiration of the Section 21 notice. 56 days ended. Council discharged relief duty, saying it had suitable accommodation for at least 6 months. But landlord applied for a new notice, applied for a possession order, but couldn't use the previous one. Is that because it ran out of time? The family asked for a review of the end of relief duty because the fresh new Section 21 notice and because the landlord applied to court. The council doesn't want to state they're not homeless despite it, saying that the family has to prove that the landlord's applied for a possession. Sorry, I'm just trying to read this. The council has. So, I mean, just to make the point, so if the council's accepted the relief duty, they have accepted you are homeless. That's how the relief duty kicked in. For a relief duty to start, the council has to be satisfied, not just having reason to believe that you might be, but they have to be satisfied you are in fact homeless. So, yeah, although they might just not understand that. But anyway, prove that the landlord has applied for a possession order. I mean, the bottom line is, again, I mean, this is what the law says. It's the council's job to basically make those inquiries. You shouldn't have to like prove that the landlord's done that. The council should be contacting the court or contacting the landlord to get evidence of that. Can they ask an applicant to prove that the landlord's applied for possession order when they have the details? Yeah. So not, I mean, no, yeah, no, they can't. Obviously, they can't legally, but they can in the real world. So what I'd say here is that potentially this might be a situation where you just want to put a little complaint in and just say, look, this not, yeah, effectively trying to think which case it is, which says about not proving the case, and actually whether it says that in the code of guidance. Yeah. So this is an excerpt of, I mean, this, okay, let me hold on, let me get this up. So this is actually talking about this idea within the field of intentional homelessness. However, it's the same principle that applies elsewhere. So it's for the housing authorities to satisfy themselves in each individual case with an application can't become. So that's, as I say, this is all about intentional homelessness, but it would relate to any kind of question of the homeless application process. Generally, it's not for applicants to prove their case. So this is actually, I mean, this is, yeah, let me see if I can find a better example of this, because in fact, if I look for the word burden, because that's, again, that's the law, that's the kind of way that the case law said. Yeah, so it's not coming up. I can't remember which case it's in. I think it's maybe, oh, Always v Birmingham or something. I can't remember now. But so basically the law is clear. It's the council's job to make the inquiries. Yes, the applicant should cooperate, but when you've got something like this where the council basically has, you know, has the information they need to hand, I think you just need to complain. That's probably my answer. Again, I think that probably just kind of ties up everything in that question, actually, to be honest, because I think, yeah, basically it's not, yeah, the council's just been difficult, basically, and so the only way you can kind of fight that is to get the council to complain, basically, to get them to stop doing it. So yeah, Karis, could you see anything in that question that I've not just covered?
Yeah, if they've not been given a decision yet, but at the stage when they ask for a review of that decision, it should be an independent person. It just sounds like the housing officers, again, not doing what they're supposed to be doing and making the right inquiries, and genuinely just it's kind of like looks like a mess. So if they keep their documents in order, you should be fine.
Yeah, cool. Number 10. Can I relocate to another area as my council can't offer support? Led to no GP but long-term sick. So I think this is actually this is on the back of this. So this is, in fact, if I just put this together with the previous question, I think this is from up here. Um, so here, so this is the same person anyway. So I'm assuming it's the same thing. Um, can I really get to that? So this is someone who's already in temporary accommodation. So yeah, this is the difficulty. Once one council has accepted the main duty for you, which I'm assuming what's happened here, if they've been in TA for 2 years, um, then yeah, basically you're kind of locked in with that council, and so really to get that situation resolved, you need to challenge that council, that council A in this case. So you need to complain and kind of make the. It's a very, you wouldn't even have to kind of quote any law if your complaint was simply, I've been stuck in this hotel for 2 years and I've got no cooking facilities. That would be enough probably to get through to the LGSCO eventually, and for them to do something about it. There might be some other bits and pieces that can be done around. Um, Basically, it gets complicated. If you complain about the kind of standard of your TA or the suitability of your TA, it should also be taken as a section. It should be taken as a request for a review of the suitability of the property. That gets a little bit complicated to explain. So, but it basically should, if you put that argument forward, you're going to make the council give a response to it, and the response is likely to be negative and basically ignore what you're saying. But that's just the first stage. And but if you get them to give that response, you can then potentially take that down the complaints route and kind of get a little bit more, yeah, a bit more weight to it if you were to do that. So, but yeah, once you've applied to one council and they've accepted the main duty, though, unless you then become homeless again, you can't approach a different council. So yeah, that's kind of, that's why it's so important you kind of work out which council you want to apply to in the first place. I appreciate there's not always an option with that, but where you can choose it, it's going to be important to work that out. Um, so next question. My friend is trying to get her property moved from temporary temporary to the interim, from temp to the interim, from temporary storage to the interim accommodation. Council is making it very difficult, saying they provided the council list for storage options only. Should they abandon the items? No. So that's so if I've just read that question right, and correct me if I'm wrong. So the council's duty to protect property is not just about having a list for storage options only. They basically need to do, they whatever the wording was, take reasonable steps to protect the property. If we go back to chapter 20 again, let's just dig up what the actual wording was, because it's going to definitely say it better than I can at this time of night. So whether or not the housing, it must take reasonable steps to prevent the loss of or mitigate the damage to any personal property of the applicant. So the reasonable steps, that isn't just, well, we've got a list of storage options. That's not. There are other reasonable steps that councils might have to take. For example, transporting property from a storage unit to interim accommodation, if that's actually makes sense, to be honest. So I think, again, if it was me, I'd complain and just say you're basically being too narrow with your kind of idea of what reasonable steps actually are. They are much broader than that, and it could be even broader than that. Still, there will be a reasonable step is anything that's reasonable in the circumstances, and given how varied circumstances can be of people who are homeless, there will be other things that councils can also do that just don't crop up very often, but they can do them. So a council can't just say, "Oh, we don't do that." It's like, well, you can't, you have to do that. If that's what a reasonable step is, then you have to do it. You can't just say we only do this thing over here if the situation basically requires it. So let's see if there's any kind of clarification on that. But I think if I've read that question correctly, then I'm hoping that's the answer. So question 12. So there's a question here: how long will it take to get any accommodation when full duty is accepted? So if you go, I can't answer that here. However, I have done a very extensive video about this. If you search on this YouTube channel, how long does it take to get housed? There is a video I did where I basically researched the average waiting times for every district. And so in that video, down the bottom is the average waiting times for each bedroom size for each council. But you have to, the reason I put it in the video rather than just giving to an Excel sheet is because you have to understand the caveats in the video. Otherwise, it's meaningless. So you need to watch that video in total to see how the data should be read, because their averages, which can mean, sometimes people get housed, in 5 days or something, when the average is 5 years. That's the way averages work. It just means someone else is getting housed after 10 years. So you just need to watch that full thing. But rather than answer it here, check out that video. How long does it take to get housed? I did it like January this year, so it's quite a recent one. And basically have a look at the data in that just to kind of get an idea. Part of the reason I did that video was to give people who are fleeing domestic abuse and they don't care where they go an understanding of how much it varies. Because I keep saying this, Bassett Law's average waiting time is 6 days for like I can't remember, like a one bed or something. In Kingston upon Thames for a four bed, it's 87 years. So it massively matters where you apply if you've got the choice, which you don't always have. But if you do have the choice in certain circumstances, then yeah, it matters as to where you actually want to apply. And generally, the further away from London you are, the quicker it's going to be. But that's a general rule. Um, let's check in on the questions here, see if we've missed anything. Yeah, so this is a continuation of that previous question. I mean, I would say we're doing our best here to follow these questions, but when they are kind of like written like over long things, it's quite difficult to follow. But just this last bit, the family is still waiting for the review decision after 10 weeks when it says 8 weeks. So you just need to make contact with the council about that and chase them for it. I think this question came up maybe in Will's live stream or something, or maybe Will and Kara said it last week, but basically you can't really not agree to an extension. They should have written to you basically saying we need an extension. Um, I've had experiences where I basically complained as soon as they didn't provide it, and they did provide it. But yeah, Will and Karis know more than me, so I'd suggest that yeah, basically just chase the council down to find out what's going on with it. But then they'll basically come back and say, "Oh, we need an extension of like 4 weeks or something." And basically, at that point, you just need to agree to it. Um, cool. I think I've answered that one already. I think I've answered that one too. Hey, you up, Michael? Okay, so I'll put this in here. The answer is yeah, person waiting for a decision or review of Section 202. It sounds like it's for a non-priority decision. Council requested extension 2 weeks. List to help in the person. Strong medical evidence. Possible outcome of the decision, please. I mean, yeah, as I say, how long's a piece of string? Without knowing the details, I haven't got a clue. However, in my experience, without knowing anything about this situation, my experience of getting decisions overturned for non-priority is basically like shooting fish in a barrel. If you've got a solicitor, it's basically, if you've got strong medical evidence and a solicitor, it's a very good chance you're going to win it. Maybe not the Section 202 stage. The council might be that difficult, and then but then the solicitor will basically just go down to Section 204. And as I say, the threshold for vulnerability, which I'm assuming what we're talking about here, is not very high. It's basically something, the key word is noticeable. Is there something noticeably different about you as opposed to a hypothetical healthy and robust person, which is basically going to put you at more risk of harm if you're homeless? And the answer is almost certainly going to be yes, if you've got a serious medical issue. So yeah, so I mean, I haven't don't know anything about this person's situation. However, even without knowing that, I'd still say the chances are very good for this person. Um, cool. I think I've done that one. So yeah, with storage costs, councils basically they can charge you for it, but it's got to be at an affordable amount. So yeah, I mean, there's talk there about £115 a month. Well, if that's not affordable, then the council's not discharging their duty properly. There are again, there's some LGSEO decisions about storage of property, which I've put some stuff on recently, basically on the channel, I think. But again, it's just interesting to see how they basically factor in and how they look at those kind of situations. Um, yeah, yeah, it's 87 years in a B&B. Yeah, I mean, bear in mind, guys, most councils in the country don't use B&Bs that much. It's just London councils that do it. Well, not just London, but a lot of areas don't use B&Bs anywhere near as much, which is another reason if you can move away from London, then yeah, then it's not a bad idea for that reason as well. Um, I think that brings us to the end of the questions that in the live chat. We'll go back to that final question that came in through the week, and then we're done, hopefully. Um, so question 14. I'm currently trying to get housed in central Bedfordshire. My dad has lived in the area for 4 years. I was living in rented accommodation in the area for 18 months and since have been homeless, spending weekends at my dad's. Is this enough to get priority? He lives with his girlfriend. There's not enough room and it caused a lot of problems me in there. And they're currently living in my van during the week and I have recently had a mental health assessment, which I'm just waiting for the results. Thanks a lot. Okay, so um, let's break this down. So the question of whether this person's homeless. This person's not anything other than homeless. They're living in a van most of the time. They stay very short term in their family. They're legally homeless. That's that check done. The question of priority need is going to basically probably depend a lot on the mental health assessment and the outcome of it. So yeah, I mean, the council should house you in the meantime. Basically, that's why the threshold for providing interim accommodation is so low, as in reasonably that they might be in priority need. Well, I would argue very strongly that if you're getting a mental health assessment, then there's reasonably that you might be in priority need. That's the way it works. But so that kind of defines that. Um, Bear in mind that this person wouldn't necessarily have local connection to Bedfordshire through their father because he's only lived there for 4 years, and the law says they need to live there. The family members need to live there for 5 years. However, this person themselves has lived in it. It sounds like they've lived in the area for 18 months. Now, again, the threshold on local connection for homeless applications is either 6 out of the last 12 months or 3 out of the last 5 years. So if this 18 months includes 6 out of the last 12 months, then they have local connection to central beds anyway. But even then, even if they don't have local connection, there is a video about this on the channel which is called "What If I Don't Have Local Connection?" That doesn't actually rule you out of being housed by essential beds as a homeless person. So I think what this person, if they haven't done it already, they need to make a homeless application to central beds. Have a look on the YouTube channel for the video, the best way to make a homeless application, and follow every single step in that process. That's why I made that video so long, because if you want to do it, you want to do it properly. If you basically skip some steps, you're basically just making it harder for yourself down the line. So watch that video, follow the steps in the video, approach Central Bedfordshire in via an email, making a homeless application via an email, and essentially see what happens. But there's no reason to wait to make the application. There's no reason not to do it now. You're right, Flabby. Um, I think that anything else in that one, Karis? I think
I
that
would
covers it.
get documentation of your mental health assessment.
Yeah, cool. Yeah. I mean, and if you've got existing diagnoses and any other medical issues that might be relevant, I mean, basically any medical issue is probably going to be relevant to priority need. I did see a good example of one that isn't. So severe acrophobia, so fear of heights. You might have a crippling fear of heights, but because that's not relevant to being homeless, that would not be something relevant to priority needs. But that's just kind of like, yeah, that's kind of an example of when it wouldn't kick in. If you think about it, most medical conditions will be affected by being homeless. Whether they're mental or physical health conditions will be affected by being cold and wet and damp and at risk of exploitation and people beating you up and stuff. Those kind of things are obviously going to, be relevant to the question of priority needs. So yeah, cool. Thanks, guys. I'm going to say we're going to be back a week tomorrow, but I'm so unorganized at the moment. I might have to put another one on Wednesday, but I've got no reason to think that's going to happen. So we'll be back on this channel week tomorrow. I believe that Will is going to be available on Monday. He's ridiculously busy at the minute, which is why I don't think he did the stream on this Monday. If you've got questions about this sort of stuff, then I would recommend just putting them on any video comment as a fresh comment on any video on the channel, rather than using the live stream, just because it gets quite difficult to follow. Someone did ask for the hold on. Someone asked for the Virgo link. I mean, the link, I'm not sure if it's going to fit in the chat, but just to bear in mind, guys, it sounds like they're at capacity at the moment, but that can change fairly quickly depending on what's going on. So see if that, yeah, it does fit in. So there's the link, that kind of the initial assessment sort of self-referral form. But just be patient with them, because particularly, I mean, it might be interesting for you guys to kind of, or it'd be interesting for me to hear the day in the life of solicitor. Things can be going really nicely, and all of a sudden you've got two court dates the same week, which I think is what happened to Will, and suddenly all of your plans go out the window. So that's the reality of, that's who you're trying to get to help you, is people who are basically called away at a moment's notice and have to, stay up all night studying for the next case. So that's the way it works. But yeah, I'll try and put, I'd say, on a couple of those points that came out tonight. So the kind of single people in single people in hotel accommodation, I'll have a look to see what stuff would be relevant to that. So there is some stuff that would be relevant, and same thing around having to pay for, like, kind of buy ready-made food and stuff like that. Um, yeah, so just that last question, the answer's a resounding yes. But the council is very likely, because the council, in my opinion, act immorally a lot of time. Lots of councils do. They'll basically push back very hard. But the situation like that, where you've got debilitating depression and mental health issues, yeah, absolutely, yeah, 100%. Cool. We'll see you a week tomorrow, guys. Take it easy. Thanks, Karis. And hopefully this has been half